What's up, everybody? This is Stephen A. Williams, president and founder of the creditrepairshop.com, and in today's video, we're going to talk about what is the potential responses that you could get when being sued by a debt collector in court. One of the biggest issues that don't say issue. One of the things that we've been seeing with the back and forth when we do our pro se defense or when people put that together for themselves, because I have a link where if you're being sued by a debt collector, I'll give you the documents where you can, and a video showing you how to do your response to the citation or the court summons complaint, and at least have some type of opportunity to win either in court or to have them just dismiss it before that. But it does have to be a third party debt collector. Now, what I have here in my hands was one that was responded to by a third party debt collector. And what you will see a lot of the times is that, especially before the pandemic, it's kind of changing a little bit now. But debt collectors will hire an attorney in your area where you live at, because these debt collectors, they're based in other states, and unless you live in their state, they're going to hire out someone to do a summons complaint to bring you into court. And so this is where, when it's third party, this is why it's so important that you at least consider this opportunity to win your case when dealing with third-party debt collectors. Because when a third-party debt collector buys your debt, they'll have all of these different affidavits attached. Maybe a lot of them don't even go that far, but they'll attach affidavits to there saying that the information that they got from the original creditor is 100% true, and they maintain their books in a legal way, blah blah blah. They say all of that stuff. But this is where we've been winning, and I'm going to tell you what the debt collectors have been doing on the comeback, because just like anyone that is spending money to try to get money, they want to win this so they can get paid. They're not going to just always just sit down and not do anything. They're going to try to come back and see what you're going to do about what they responded to. So when you do a court summons response to a third party debt collector, you always want to mention, and I'm just briefly going over it, you always want to mention if a lawyer reviewed all of the documents pertaining to what they're claiming in the citation. Because in the citation or the court summons, what they're claiming is that you owe a certain amount of money. A specific amount of money is what they're claiming. Minus all their fees and all that stuff that they try to throw in there, what we're focused on is the amount of money that they're claiming that you owe. And they're saying that they purchased that debt from a third party, from a original creditor, and that you have to pay them that whole amount. Now, there's already problems with that, but let's just go, like it would normally go. They're saying that you owe a certain amount of money. So when you respond back to them and you do a debt validation within your court summons answer. So when you answer the court summons, you ask in return for them to prove the amount. Now, we're not talking about proving that you have to, proving that the debt is yours and all of this stuff, because that's taking you down a road that's probably not going to work. What we're trying to do, and what we always do, is we try to get them to establish the amounts and also establish the chain of custody. They already saying that they were hired by they're the plaintiff attorney, so it doesn't make any sense to try to say, why do I have to pay you? but you are making them establish, if they haven't put it in an affidavit with the court summons complaint or the citation, if they haven't included that affidavit about how they came in control of the debt, then you do ask for a contract and you want to get all of the information about why you owe this third party debt collector. But let's just say that they put all of that together. They got the affidavits, they got the bill of sale from the original creditor, they got all of that information like they got with this one here. The next step is to challenge the amounts that they're claiming. And when we did that challenge, and that's in the response to the court summons, they, this is crazy. I'm just going to read it to you. In regards to your dispute of the above referenced debt, please be advised that a lawyer in this office has reviewed the information in your file. They're speaking about our client. We have been in contact with our client concerning your dispute. Our office has verified that the debt is due and owing. Furthermore, our client has sent the endorsed documents as further verification of debt. Please be advised that these documents are those of our client. They were not prepared in our office. Right there, that last sentence. Please be advised that these documents are those of our client. They were not prepared in our office. Now, so this is the response that would be needed in the follow-up to this here, is that you would ask for them, because they're going to be the ones that's representing their plaintiff, their client, the plaintiff, in court. And they're saying that all of this information that their plaintiff gave you is true, but the person who is in court arguing against you said in a letter that the documents were not prepared in our office. Now, we don't expect them to have the documents prepared in their office, but we do expect them to have reviewed everything, and they're going to have to say that everything in those documents are true. And so this is where we get to where, if you have the tolerance, what you have to do when it gets to this step is you do two things. Is that you respond to them saying that that you disagree with the amounts, you disagree with the accounting, everything. If you disagree with it, I'm not telling you what to do, I'm telling you your options. That you disagree with the accounting and everything, because they've just admitted, number one, that the documents were not prepared by them, and then number two, in their letter that the plaintiff submitted to their attorney, states that they were not in the office of the original creditor who prepared the documents. So what you would do is you would submit to them saying that you would like a full accounting of everything that they're claiming. And then they would in turn go to their client, who is the third party debt collector, and ask them for a full accounting of everything. And then the original creditor, the third party debt collector, who is the plaintiff on here, would have to then go to the original creditor and try to get more information about what you are disputing with this. That right there is a step that they potentially do not want to go through, because number one, everything is usually sold and given to one big debt collection firm. The smaller ones don't buy these packages from them. They are bought by big portfolio companies, and then they are given purchased by smaller debt collection companies. So they have no relationship with the original creditor. They pretend to have one, but they actually have no relationship with the original creditor. So they will not be able to get the documentation to dispute exactly what you are disputing, which is the amounts, your payments, the interest rates that they charged, all of that stuff. Now, they might submit some statements and stuff like that, but that's not going to be enough if you have the tolerance. Listen to me. If you had a tolerance, and what I mean by the tolerance is to go into court and to argue those points and push as hard as you can to get all of that proof. Now, I'm not saying that you're going to win. What I'm saying is that it gives you a chance. And if all we want when we're going through stuff like this is a chance, and then worst case scenario is that you back them into a corner or they approach you about doing a settlement on the debt because they purchased the stuff for pennies on the dollar. Basically, if they've hired a an attorney in your area to collect it, you're already going to have a certain amount of billable hours that's going to be attached to the collection of the debt. So let's just say, for example, like with this individual owed over $7,000. They're not going to get $7,000, but they would potentially settle this for the amount that they have to pay the attorney for going to court and the and some money for them because they paid pennies on the dollar. Let's just say ballpark 1,000 or 1,500, 2,000 max. This could be settled for. Also, don't get afraid of the amount that it could be too high for the law office in that area to have taken you to court. You're not the only one that they would have had in there. They do multiples. So it's not going to be like it's just like your fees are so much for this one deck for this one attorney that's going there. They usually bundle these up where they're there to see multiple clients for their plaintiff in that area. So I'm going to end it here. So the first thing that I want you to do, if you have a debt collector that is coming after you, threatening to sue, you need to get my free debt collection letter. And I have two letters. Two letters. The first one is if you get that demand letter, there is a cease and desist demand letter that I would like for you to send. This could actually stop debt collectors dead in their tracks because it has a lot of information in there that you would want. And if they don't believe that they can jump that hurdle, they would potentially just say, we're not going to come after you for that debt. And they'll usually write a letter back stating that they're not going to. The next one is if they do not stop with that cease and desist letter, we have another one that is a debt validation letter. And you should send that letter because that's giving you a head start on doing a debt validation on the debt that they're claiming. And that could potentially get them to stop. Remember what they had said here about that an attorney in their office had reviewed the file. Well, in a good debt validation letter, you want to ask them up front before it even gets to this court stuff. Has an attorney reviewed the file? Because a lot of the times, if you look at your demand letters from debt collectors, they say that an attorney has not reviewed the file, and there's a reason behind that. They don't. If they start to review the file, then everything that they say from the call from that customer service rep for the debt collector, there's certain things that could be placed on record because remember they're recording, and if they say that a debt collector reviewed everything and then that customer service rep says something that's outside of that bound, then there could be trouble. That's why they always state that the attorney has not reviewed it in the demand letter. They're just giving you a chance to dispute the debt. They say that an attorney in their office has not reviewed anything, and then an attorney will review it after they go and submit to take you to court. That's when an attorney will review it. So get my debt validation letter. Also with that debt validation letter, something that you should, there's another letter attached to that. If you get a demand letter for debt, you should always check the statute of limitations to see if they can even legally come after you for this debt. You've seen in my other videos where I talked about debt that's being sold on the market that is past the legal statute of limitations to even be able to collect. So you should always check to see what the statute of limitations for collecting debt is in your state and what statute of limitations means is that there's a limit if it has not became a judgment. Judgments can last for 20 years. If it has not became a judgment, the original creditor, you haven't made any payments or anything within a certain period of time, that debt becomes void. It's a time barred debt. They cannot come after you for it. There are debt collectors right now that are being sued by the federal government for going after people, and they don't even notify them that you don't have to pay this debt. They'll use certain types of lingo like time barred, or you have a moral obligation to pay this debt, but you don't have a, they don't outright say you don't have a legal obligation to pay the debt. So if it's past the legal statute of limitation, I want you to use letter number one in my debt validation. You can get with the debt validation letter link, use letter number one, and you're just notifying them that they're attempting to collect a debt that's past the legal statute of limitations to collect in your state. If you do not know the legal statute of limitations to collect debt in your state, go to my website, thecreditrepairshop.com. Link is below. Go to my blog and then type in statute of limitations, and you'll get a link that'll take you to the page to see the legal statute of limitations for debt to be collected in all states. In the fourth column, please pay attention to this. In the fourth column, that is for credit card type debt. The fourth column, open end debt. That's the fourth column. All other debts like repos, or maybe you had an account with someone that doesn't allow you to pay it and then have more access to the cash like you do with a credit card. That's all in column number one or column number two. And so that we'll end it here. In my next video, I'm going to make a series of videos here because I'm going to be very busy doing some medical stuff with my wife. So I wanted to at least make sure I made some videos to talk to everybody. If you haven't yet, please subscribe to my channel. Please post your questions and comments. I've been getting very good at answering more and more as possible. And I would like to just thank everybody. And remember to stay positive, keep fighting. Once you make it to the other side, all of the stuff that you're going through is going to seem like really nothing. All right, this is Stephen A. Williams, President and founder of thecreditrepairshop.com. Thank you, and until next time.